My husband secretly transferred all our property to his mistress and filed for divorce. My lawyer shouted, "Don't give up!" But I silently signed everything. He celebrated. I laughed. He had no idea that... Good day, dear listeners. It's Diana again. I'm glad you're here with me. Please like this video and listen to my story till the end, and let me know which city you're listening from. That way I can see how far my story has traveled. There are marriages that end with a fight, and there are marriages that end with a silence so quiet you don't even notice it happening. Mine was the second kind. Daniel and I had been married for 19 years. We built our life the way people in movies do. Slowly, deliberately, with a kind of pride that felt earned. I was a licensed architect. He was a commercial real estate developer. We met at a conference in Denver when I was 26 and he was 31, and he had this way of walking into a room like he already knew where everything was. I found it magnetic then. Later, I would find it terrifying. We bought our house in Lincoln Park, Chicago in 2009, right after the crash, when everyone said it was a foolish time to buy. It was a Victorian brownstone with original crown molding and a leaky third-floor bathroom we spent 2 years arguing about how to fix. We fixed it eventually. We fixed most things, or I thought we did. Our daughter Lily was 17 and applying to colleges. Our son Marcus was 22 and already working as a junior analyst downtown. We had 2 cars, a joint account, a beach house in Michigan that we used every July, and a retirement portfolio that we'd built together through the lean years. I designed buildings for a living. Daniel filled them with tenants. Together we had made something solid. Or so I believed. The first time I noticed something was wrong, I dismissed it as stress. It was a Tuesday in October. I came home earlier than expected. A client meeting had been canceled, and Daniel was standing in the kitchen with his phone pressed to his chest, the way you do when you don't want anyone to hear what's on the screen. He smiled at me. He asked about my day. He made pasta for dinner. I didn't think about it again for almost 2 weeks. Then there was the credit card. Not the joint one. A different one. A name I didn't recognize on a statement that arrived in the mail by mistake, forwarded from an address I'd never heard of. Daniel intercepted it before I could read the full name, said it was junk, dropped it in the recycling. I fished it out later. The account was 6 months old. The billing address was a property he managed on the north side. I told myself there was an explanation. There wasn't. Over the next 3 weeks, I started noticing things I had trained myself not to see. The way he always angled his laptop away when I entered the room. The overtime that never appeared in our shared calendar. The Saturday site visits that left no gas receipts, no mileage, no trace. The perfume on his collar that wasn't mine. Light, floral, young. I didn't say anything. I watched. My sister told me I was paranoid. My best friend Karen, who had been through her own divorce, said nothing, just looked at me the way people look when they already know the answer and are waiting for you to catch up. I caught up in November. I had driven to his office unannounced, something I almost never did. I told myself I was just dropping off a birthday card for his assistant, which was true. But when I stepped off the elevator on the 14th floor and looked through the glass partition into the conference room, I saw him. He was sitting at the head of the table, leaning toward a woman I didn't recognize. She was perhaps 32, with straight blonde hair and the kind of careful clothes that suggest effort. His hand was on hers, not a business gesture, something else entirely. I stood there for perhaps 4 seconds, long enough to understand everything, short enough that neither of them saw me. I took the elevator back down. I sat in my car in the parking garage for 20 minutes. Then I drove home, made dinner, helped Lily review her Common App essay, and said nothing. That was the moment I stopped being a wife and started being something else entirely. 3 months later, Daniel handed me a thick envelope across the kitchen table. His expression was composed, even kind, the look of a man who has rehearsed his performance carefully. "I think we both know this has been coming," he said. Inside was a divorce petition, and folded beneath it a set of property transfer documents I was not supposed to have seen. Transfers dated 4 months earlier. Every significant asset we owned rerouted to a woman named Kristen Walsh. My attorney, a sharp-edged man named Gordon Reeves, called me the same afternoon Daniel's lawyer filed. "Do not sign anything," he told me, his voice sharp enough to cut glass. "Do not negotiate. Do not let them think you're weak. We fight this. Every dollar." A week later, I sat at a conference table with Daniel across from me and his attorney beside him and signed every page they put in front of me. Daniel smiled. I smiled back. He had no idea why. The night I signed those papers, I drove home alone. Daniel had offered to share a car. The audacity of that. And I had politely declined. I sat at the kitchen table with a glass of water I didn't drink and thought about what I had just done and why I had done it. Let me explain something. When most people say they signed divorce papers without a fight, they mean they gave up. They mean the grief was too heavy, or the lawyers were too expensive, or they simply didn't have the energy left to become a person who fights. I understood that. I had felt all of those things in waves, standing in my own kitchen at 2 a.m, looking at documents that erased 19 years. But I hadn't signed because I gave up. I had signed because I had already started. Let me go back to the beginning, the real beginning, not the one Daniel had scripted. 2 weeks after I saw him in that conference room, I called Karen, not to cry, to ask her a specific question. Who had she used when she went through her divorce 6 years ago? She gave me a name, Margaret Okafor, a family law attorney in Evanston. "She's not cheap," Karen said. "She's also not the kind of person who loses." I met with Margaret on a Thursday morning in her office overlooking the lake. I told her everything. She listened without interrupting, which I appreciated. Then she asked me a question that changed the shape of my thinking entirely. "When did the transfers happen?" she asked. I showed her the documents I had photographed on my phone, the ones from the envelope Daniel had slid across our kitchen table with such misplaced confidence. Margaret studied them for a long moment. Then she looked at me and said, "These transfers happened inside your marriage, using marital assets. Illinois is an equitable distribution state. This isn't over. This hasn't even started." I went home and sat with that for a long time. Here is what I had lost, on paper. The Michigan Beach House, transferred to Kristen Walsh, LLC, a company Daniel had filed 4 months ago, using an address I'd never been told about. The investment portfolio, restructured through a trust I hadn't signed, hadn't known about, hadn't been consulted on. A piece of commercial property on Wacker Drive that Daniel and I had bought together in 2017. The one he always said was our retirement plan, transferred to the same LLC. Our home in Lincoln Park. That one he hadn't touched. Probably because it was too visible, too obviously mine in the way that only a house you've lived in for 15 years can be. Or perhaps because he thought leaving me the house would look like generosity. The total value of what he had moved, Margaret estimated conservatively, was somewhere between $2.1 and $2.4 million. I sat with that number for a long time. Fear is an interesting thing. I had expected it to feel like panic, racing heart, shallow breathing, the particular nausea of realizing you have been betrayed on a scale you couldn't have imagined. And it did feel like that for about 48 hours. I cried in my car twice. I stood in Lily's doorway one night and watched her sleep and thought about what I was going to tell her, and the weight of it almost flattened me. But then something else arrived. Not anger. I had moved past anger faster than I expected. What arrived was something colder and more useful. Clarity. I am an architect. My entire professional life is built around one simple truth. Before you can fix a structure, you have to understand it completely. You have to know where the load-bearing walls are. You have to know which elements look strong and aren't, and which ones look fragile and will hold. You have to know the building better than the people who thought they built it. Daniel had made a very specific miscalculation. He believed that because he had managed most of our finances over the years, I didn't understand them. He confused delegation with ignorance. I had trusted him. That was not the same thing as not knowing. I spent 2 weeks quietly pulling records, bank statements I had access to from joint accounts going back 7 years, property records, which are public, business filings for Kristen Walsh LLC, which Daniel had registered through Illinois' online portal and apparently hadn't thought to obscure. I photographed everything. I organized it in a folder on my personal laptop, password protected, and stored a copy on a flash drive I kept at my office. I told Daniel nothing. I called Margaret and told her what I had found. She said, "Good. Now here's what we're going to do." The plan was not complicated. It was methodical. The core of it was this: we would let Daniel proceed as though he had already won. We would not challenge the divorce petition immediately. We would not freeze assets. Not yet. We would gather, document, and wait for exactly the right moment. Margaret explained that in Illinois, the court retains jurisdiction over marital assets, even if they've been transferred, provided we could demonstrate fraudulent conveyance. We could. We already had the documents. "He's going to celebrate," Margaret said. "I know," I said. "Let him." The first official step was quiet enough that Daniel didn't notice it at all. Margaret filed a motion for full financial disclosure. Standard procedure in any divorce, nothing alarming on its face. Under Illinois law, both parties are required to disclose all assets, accounts, and financial interests within 30 days of being served. Daniel's attorney, a man named Clifford Baines who wore expensive suits and a permanently self-satisfied expression, acknowledged the motion without comment. They filed their disclosure 2 weeks later. I read through Daniel's financial disclosure on a Sunday morning at my kitchen table, coffee cooling beside me. He had listed 11 accounts. I had documentation of 14. He had listed 2 properties. I had documentation of 4, including the Wacker Drive property and the Michigan house, both of which were now titled to Kristen Walsh, LLC. In the disclosure, he had listed neither. In the space for business interests, he had written, "None currently held." I photographed every page of his disclosure. Margaret called it a gift. "He's lying under oath," she said, "which means we have him for perjury and fraudulent concealment on top of the asset transfers. He just made our case considerably stronger." But I want to tell you about the moment that mattered most. The moment that took this from a divorce proceeding into something I hadn't fully anticipated. It was a Wednesday, late January, about 6 weeks after I'd signed the preliminary papers. I was working late at my firm's office downtown, finishing construction documents for a mixed-use development in Wicker Park. The office was quiet, just me and the glow of the drafting software and the particular stillness of a Chicago night in January. My phone buzzed. It was a message from a number I didn't recognize. "You should ask your husband about the refinancing on the Wilmette property." I stared at it for a long moment. Then I typed back, "Who is this?" No response. I sat there in the quiet office thinking. The Wilmette property was a 6-unit residential building Daniel had acquired in 2018, nominally for a client, though I had signed a personal guarantee on the original loan. If he had refinanced it, if he had pulled equity out of it, and hadn't told me and the loan had my name on it, I called Margaret the next morning. She was already ahead of me. She had a contact at a title company who owed her a professional favor. Within 48 hours, she had the refinancing documents on the Wilmette property. Daniel had pulled $340,000 in equity out of it 11 months ago. 4 months before he filed for divorce. 3 months before the first asset transfers. The refinance was filed under his name alone. The proceeds had been deposited into an account I had never seen before. An account, it turned out, that was linked to Kristen Walsh. That was the moment Margaret said, "This is no longer just a divorce." She was right. What Daniel had done wasn't just ethically devastating. It was legally actionable on multiple fronts. Fraudulent transfer of marital assets, financial concealment, potential bank fraud depending on how the refinance had been documented. The picture was becoming very clear and very damning. I thought about Kristen Walsh. I had seen her once, through glass for 4 seconds. I had spent the following months building a case, not thinking about her as a person, but as an element of a legal problem that needed solving. But sitting in Margaret's office with those refinancing documents in front of me, I found myself wondering, did she know? Did she know where the money had come from? Did she know she was holding assets that belonged, legally and morally, to someone else's marriage? It didn't change my strategy, but it changed how I thought about the ending. Meanwhile, something was shifting in Daniel's behavior. It was subtle. He wouldn't have known I was watching closely enough to see it, but he started asking casual questions at dinner, on the evenings we were both home, that weren't quite as casual as he made them sound. Questions about my workload, my schedule, whether I'd spoken recently with Karen. Once he asked if I'd talked to a financial advisor. I said I'd been too busy. He nodded. He seemed satisfied. But 2 days later, his attorney filed a motion to expedite the divorce proceedings. They wanted to move the timeline forward by 60 days. That told me everything I needed to know. They had sensed something. Not specifically, not yet, but enough to feel the ground shifting underfoot. They wanted this finalized before I could get traction. Too late. Margaret had already sent our first counter motion to the court, a petition to invalidate the asset transfers on grounds of fraudulent conveyance, with Exhibits A through Q attached. 37 pages of documentation, 14 accounts, 4 properties, 1 refinancing, 1 LLC, and a message from an anonymous number that I still didn't fully understand, but intended to follow up on. The point of no return had passed. I hadn't told Daniel yet. I didn't need to. He would find out the way people like him always do, in a courtroom in front of witnesses with nowhere to go. The motion landed in Clifford Bain's office on a Thursday morning, and by Thursday afternoon my phone was ringing. It wasn't Daniel's attorney who called. It was Daniel. I was standing in a client's half-finished lobby in Fulton Market, blueprints in hand, when the call came through. I let it go to voicemail. He called again. I let that go too. Then he sent a text. "We need to talk tonight. This is not something you want to escalate." I read it, put my phone in my bag, and went back to reviewing the structural drawings. By the time I got home that evening, Daniel was already there. He was sitting in the kitchen, my kitchen, the one I'd picked the tiles for, with the kind of forced composure that looks exactly like someone trying not to show how frightened they are. "You went to court," he said. "Margaret went to court," I said. "I made dinner plans. Do you want anything before you go?" He stood up. For a moment, I thought he might raise his voice, but he caught himself. He was always good at catching himself in public spaces. Our home, apparently, still qualified. Megan. His voice dropped to something that was meant to sound reasonable. "You don't understand what you're doing. Those transfers, there are tax implications, there are business relationships involved. You could blow up things that affect both of us." "I think you mean things that affect you," I said. "I'm trying to protect you." I looked at him for a moment. 19 years, 2 children, a Victorian brownstone and a beach house and a retirement portfolio, and a refinancing that had moved $340,000 to a woman named Kristen Walsh. "You should go," I said. He left, but that wasn't the end of it. 2 days later, I received a letter from Clifford Bain's office, copied to Margaret. It was professionally written and deeply threatening. It alleged that my petition was frivolous and retaliatory, that the asset transfers had been made for legitimate business purposes, and that pursuing this course of action would result in a countersuit for interference with business operations. It also noted, pointedly in the final paragraph, that certain information regarding my own finances might come to light in the discovery process that could be embarrassing. I read that last line 3 times. I had nothing to hide, but I knew what it was, an invitation to back down. I called Margaret. She read the letter, said good, and filed our response within 24 hours. The response was precise and ungentle. It cataloged the discrepancies in Daniel's financial disclosure, cited the Wilmette refinancing, and noted that the court had already accepted our petition for consideration. Then something happened that I had not expected. Kristen Walsh called me. I almost didn't pick up. The number was unfamiliar, but something made me answer. Her voice was steady, which surprised me. She said she just wanted to talk, woman to woman, that things had gotten complicated, that she didn't want anyone to get hurt. "Then," I said, "you should return the assets that were transferred to your LLC. A pause, then, "That's not how this works." "I know," I said. "That's why I have an attorney." She hung up. Margaret and I discussed the call. We recorded it in our case file. We moved on. But I won't pretend the weeks that followed were easy. The legal process was grinding, slow and relentless and full of procedural details that ate time and energy. The counter motion from Baines had created a complication that required 2 additional filings from our side. Lily had noticed something was wrong between her father and me, and had started asking questions I wasn't ready to answer. Marcus, who was older and had always been perceptive, had simply stopped calling Daniel. I was holding everything together by schedule, by routine, by the particular discipline of a person who is too busy surviving to fall apart. But one Friday night in late February, after a 16-hour work week and a 2-hour phone call with Margaret going through exhibits, I drove to Karen's house and sat on her couch and cried for about 45 minutes without saying much. She made tea. She didn't offer advice, she just sat with me, which was what I needed. Then I drove home, slept for 9 hours, and spent the weekend doing nothing. I watched 2 seasons of a show I'd meant to watch for years. I called Lily and talked about her college applications without mentioning the divorce. I walked along the lake on Saturday morning in the cold and let the wind do whatever it wanted to my hair. By Monday, I was ready again. The antagonists had shown their hand. They had threatened, maneuvered, and attempted to frighten me with the specter of discovery and counter-litigation. They had retreated when Margaret pushed back. They would come again, I knew that, but so did I. The temptation came in a form I hadn't expected. It was a Tuesday evening in early March, and I was working late at home, sitting at the dining room table with my laptop and the kind of focused quiet that only exists when the house is empty. Lily was at a friend's. The dog was asleep by the radiator. Outside, Chicago was doing what Chicago does in March. Wind and a sky the color of old concrete. My phone rang. It was Daniel. I almost didn't answer. We'd been communicating almost exclusively through our attorneys for weeks, which was how Margaret preferred it. But something made me pick up. Maybe curiosity. Maybe the particular pull of 19 years. "I don't want this to go further," he said. His voice was different from the kitchen confrontation, softer, more careful. He had prepared this call. "I know you're angry. I deserve that. But Megan, what we're doing in that courtroom, it's going to cost both of us, financially, emotionally. Lily is watching us. Marcus is watching us. Is this really how you want to spend the next 2 years?" I said nothing. He interpreted my silence as softness, which was his mistake. "I'm prepared to offer you the Lincoln Park house, fully, no contest, plus a settlement of $400,000 outside of court. We walk away clean. You don't have to fight anymore." I did the math in approximately 4 seconds. 400,000 and the house against 2.1 million in fraudulently transferred assets, against the Wilmette refinancing, against a case that Margaret now described as the strongest I've seen in 12 years, against the fact that this man had sat across from me at a kitchen table for 19 years and had been quietly dismantling everything we'd built together for at least 11 months. "I'll think about it," I said. He exhaled, relief, real and audible. "That's all I'm asking." I hung up and called Margaret. "He offered 400,000 and the house," I told her. She was quiet for a moment, then, "Are you tempted?" "No," I said. "Good. Because what we're going to recover through the court is considerably more, and because accepting that offer would mean Kristen Walsh keeps everything that was transferred to her LLC, which I find personally offensive." "So do I said. What I didn't tell Margaret was that Daniel's call had done something unexpected, not tempted me, but clarified something. For months, I had been operating on strategy and documentation and the disciplined forward motion of a person with a plan. The call reminded me that on the other side of all of it was a man who still believed, on some fundamental level, that he could manage me, could appeal to my exhaustion, my love for my children, my desire for peace, could frame retreat as wisdom. He'd never understood that I wasn't tired. I was building. In the days that followed, I noticed something. Daniel and Kristen had gone quiet. No more calls from her, no more pointed letters from Baines about discovery. They were watching, assessing, trying to figure out what I was going to do. Let them watch. In the meantime, I found something I hadn't known I was missing. It started with a dinner. Karen had organized it casually, 5 women at a restaurant in Andersonville on a Thursday night. I almost backed out twice. I hadn't been out socially in weeks. The case had consumed most of my mental space. But I went, and I am grateful I did. One of the women at the table was Deborah Mensa, who worked in financial litigation and whom I'd met exactly once before at a firm event 3 years ago. We ended up sitting next to each other. She asked how I was doing, and I gave the honest answer, the version I didn't usually give, and she listened with the focused attention of someone who has processed a great deal of other people's crises professionally. "Can I give you one piece of advice?" she asked. "Please," I said. "Don't settle before discovery," she said. Offer periods are usually timed to prevent people from seeing what's in the documents. He's offering because he knows what's in there. I already knew that. But hearing it said plainly by someone outside the case, by someone who had no stake in the outcome, it landed differently. It felt like confirmation from the world. On the drive home that night, I thought about what I had: a strong case, a skilled attorney, a paper trail that told the full story, and now a small community of people who knew what had happened and were quietly, firmly on my side. It was enough. It was more than enough. They came on a Saturday. I hadn't expected them both. That was the only thing that surprised me. That Kristen Walsh was there at all, standing on my front porch in Lincoln Park beside my husband, wearing an expression of practiced sincerity that must have taken some rehearsal. I had seen her in person only once before, through a glass partition for 4 seconds. Now she was at my door. She was younger than I'd estimated, perhaps 30, perhaps slightly more. She was dressed carefully, but not expensively. There was a quality about her that I might have found sympathetic in a different context. Daniel spoke first. We were hoping to talk, all 3 of us, like adults. Like adults. I thought about that phrase for a moment, and all the things it implied. That I had been behaving childishly, that the litigation was an emotional reaction rather than a strategic response, that the grown-up thing to do was to sit down and negotiate away $2.1 million in stolen assets over coffee. I opened the door wider and let them in. We sat in the living room, the one with the fireplace I'd restored myself in 2014, the oak floors I'd refinished, the crown molding that had been the whole reason I'd bought this particular house. I noticed Kristen looking around, and I wondered what she saw. A space she thought would eventually be hers, or something that was clearly and irreversibly someone else's. Daniel spoke carefully, in the measured tones of a man who had clearly decided to lead with empathy. He was sorry, he said. Not for the relationship. That was beyond apology, he acknowledged. But for how things had been handled. The transfers had been rushed, made without adequate legal counsel, and he understood how they looked. He wanted to find a resolution that worked for everyone. Then Kristen spoke. "I know this is painful," she said. "I can only imagine how you must feel. But the truth is, the business decisions that were made were Daniel's to make. He was managing those assets. What's registered in my name is a function of how the business was structured, not an attempt to steal from me," I said. She paused. "I was going to say, not an attempt to undermine your interests. But that's what happened," I said, regardless of intent. Daniel leaned forward. And here is where the mask slipped. Just slightly. Just enough. His tone changed. Still calm, but with an edge beneath it that I recognized from years of watching him negotiate. This was the voice he used when he was done with pleasantries and wanted something. "Megan, we've spoken to a second attorney," he said. "What you're pursuing in court, the fraudulent conveyance claim, it's going to be challenged aggressively. Clifford is good, but our second counsel has specific experience in asset protection law, and there are structures in place that will make your claims difficult to sustain. This could take 3 years. Lily will be in college. Marcus will be watching his parents tear each other apart in court. Is that what you want?" He paused to let that land. "We're offering you an exit," he continued. "A fair one. The house, a settlement, and we all move forward. Or we spend the next 3 years in discovery, and you get less in the end and pay more in legal fees to get there." I looked at him, then at Kristen, who was watching me with an expression that had shifted. The rehearsed empathy had thinned, and underneath it was something more impatient. She wanted this done. She wanted the LLC, the beach house, the Wacker Drive property, the portfolio. She had been waiting for it. I took a breath. "Thank you for coming," I said. "I'll let Margaret know you stopped by." Daniel's composure cracked, just for a moment, just around the eyes. "Megan, don't do this." "You should go," I said. Kristen stood first. Her expression had closed completely. The sympathy was gone, replaced by something tight and controlled. As they walked to the door, she turned and looked at me once more. It wasn't a look of defeat, it was a look of warning. The door closed. I stood in my living room and let myself feel it. The real, physical response to being threatened by 2 people at once in my own home. My hands were not entirely steady. My heart was beating faster than I would have liked. I let it pass, and then I let it mean something. Fear, I had learned, was not the opposite of courage. It was fuel. Every time Daniel or Kristen tried to frighten me back into compliance, they reminded me why I had started, why I was still going, and why I was not going to stop. I called Margaret that afternoon and told her about the visit. "They came to your house?" she said. "Yes." "Good," she said. "That means we're winning." The hearing was scheduled for a Thursday in April in the Daily Center, courtroom 1703. I arrived early. I wore a gray blazer I'd bought specifically for this, not because I thought clothing would influence the outcome, but because I wanted to feel like myself. Professional, composed, deliberately present. Margaret was already there. Her files organized in the precise, color-coded way I had come to associate with her at her best. We sat on one side of the aisle. Clifford Baines and a second attorney I didn't recognize sat on the other. Daniel arrived 8 minutes later, with Kristen beside him in the gallery. She was not a party to the proceeding. Technically, she was a third-party interest holder because of the LLC, but her attorney had filed to allow her presence. I noted this. It told me they were nervous enough that she wanted to be there to watch. The judge was a woman named Honorable Patricia Gaines, who had been on the family court bench for over 20 years and had the particular manner of someone who has heard every possible version of every possible story. She was efficient. She did not waste time. The hearing opened with Daniel's attorney presenting their challenge to our fraudulent conveyance claim. Baines was polished and practiced, and his argument was the one Daniel had previewed in my living room. The transfers had been made as part of a legitimate business restructuring, documented appropriately, and my claim was a retaliatory filing made in bad faith by a spouse who had failed to participate in the financial management of the marriage. I listened to him describe me as uninvolved and disengaged, and I thought, good. Then Margaret stood up. She did not raise her voice. She did not make emotional arguments. She presented documents. Exhibit A, Daniel's financial disclosure listing 11 accounts. Exhibit B, bank records showing 14. Exhibit C, the Wilmette refinancing, drawn on a property with my personal guarantee, from which $340,000 had been extracted and deposited to a linked account. Exhibit D through G, transfer documents for the Michigan property, the Wacker Drive commercial space, and the investment portfolio, all dated within the marriage, all using funds that appeared in our joint tax returns from the previous 4 years. Then she presented Exhibit H. It was something I hadn't seen before. Margaret had obtained it through discovery 2 weeks earlier and had held it carefully. It was an internal email, recovered as part of the financial discovery process, between Daniel and Clifford Baines, dated 9 months before the divorce filing. The email discussed the strategic reallocation of assets in advance of a potential dissolution proceeding. It referenced by name the accounts that would need to be restructured, the timeline for the LLC formation, and the importance of completing the transfers before a petition was filed. In other words, it documented that the plan had been deliberate, premeditated, and specifically designed to deprive me of marital assets before I could protect them. The room was very quiet, Baines objected. The judge overruled him. Daniel's second attorney leaned over and began whispering urgently in Baines' ear. In the gallery, I heard Kristen shift in her seat. Then came the part I had not scripted. The judge asked Daniel a direct question, under oath having been sworn in at the beginning of the hearing. She asked him whether, at the time of the transfers, he was aware that a divorce proceeding was being contemplated. Daniel looked at Baines. Baines gave a near imperceptible nod. Daniel said, "The business restructuring was unrelated to any personal matters." The judge said, "Mr. Hart, I'm going to ask you to look at Exhibit H. In particular, the second paragraph of the second email, dated March 14th. I watched him look at the exhibit. I watched his expression do something complicated. A quick tightening around the jaw, a stillness that had nothing to do with composure. He read it. He looked up. Now, was the business restructuring unrelated to the divorce proceedings? The judge asked again. A long pause. His attorney leaned in. The pause stretched. There may have been, Daniel said finally, some consideration of future personal circumstances. Judge Gaines looked at him for a moment. Then she made a note. In that silence. The 3 or 4 seconds between the note and her next words, I felt the entire weight of the previous 6 months. The October Tuesday in the kitchen, the parking garage, the papers I had signed while everyone thought I was surrendering. Margaret's office, Karen's couch, the February morning by the lake. The judge set a date for the final ruling and closed the hearing. As I stood to leave, I glanced toward the gallery. Kristen Walsh was looking at Daniel. Whatever she'd expected from this day, it was not what had happened. Daniel did not look at me. I didn't need him to. The ruling came on a Monday morning, 6 weeks after the hearing. I was at work when Margaret called, not to prepare me, not to hedge, simply to say, we won. Not partially, not with compromise, fully. Judge Gaines' ruling ran to 41 pages. I read all of it more than once in the way you read something when you want to make sure it's real. The language was precise and legal and contained in its way everything that needed to be said. The asset transfers to Kristen Walsh, LLC, were found to constitute fraudulent conveyance under Illinois law. Specifically, the court found that the transfers had been made with actual intent to hinder, delay, or defraud a creditor, meaning me, as a spouse with a legal interest in marital property, and were therefore voidable. The Michigan Beach House, the Wacker Drive commercial property, and the restructured investment portfolio were all ordered returned to the marital estate for equitable distribution. The $340,000 extracted in the Wilmette refinancing, drawn on a property with my personal guarantee without my knowledge or consent, was ordered restored to the marital estate, with interest. Daniel's financial disclosure, which had listed 11 accounts against a documented 14, was found to constitute deliberate concealment. The judge referred the matter to the state's attorney's office for potential perjury proceedings. She noted in her ruling that this was not a close case. The equitable distribution of the marital estate, now fully reconstituted, gave me 58%. This was above the standard split, and the judge's reasoning was explicit. The concealment, the premeditated nature of the transfers, and the specific disadvantage I had been placed in warranted an adjustment in my favor. The house in Lincoln Park was already mine. Now I also received my full share of the investment portfolio, my half of the Wacker Drive property, which I immediately chose to sell, my half of the beach house, which I chose to keep, and a cash settlement drawn from the restored Wilmette funds. The total was just under $1.4 million, plus the property values. Clifford Baines, to his credit, did not call to congratulate me. Daniel called once 3 days after the ruling. I let it go to voicemail. He said he thought we should talk. He said he wanted to explain. He said, and this is the part I played twice, just to be certain I'd heard it correctly, that he hoped I understood none of this had been personal. I deleted the message. Kristen Walsh, LLC, was ordered dissolved within 60 days. The LLC had been the vehicle for everything: the beach house, the portfolio, the commercial property, the refinancing proceeds. Dissolving it and returning the assets to the marital estate effectively unwound 11 months of careful construction in a single court order. Every legal structure Daniel and his attorney had built, the timeline, the business rationale, the documentation they'd been so proud of, had been examined and found hollow. What had they been counting on? Speed, mostly. The assumption that if they moved fast enough, transferred assets cleanly enough, filed the divorce quickly enough, I wouldn't have time to understand what had happened before it was finalized. They had miscalculated on every point. I had understood. I had had time. I had been anything but quick. Margaret sent me a bottle of very good wine with a note that said simply, "Well done." I called her to thank her, and she said, without false modesty, that it had been a pleasure working on a case this well documented. "You gave me everything I needed," she said. "I just organized it." I told her that wasn't entirely true. I thought about the anonymous text message, the one that had pointed me towards the Wilmette refinancing in November. I still didn't know who had sent it. I had some guesses. Daniel had business partners and associates who had known perhaps what he was planning and had found it distasteful. Or perhaps Kristen Walsh had a conscience that functioned intermittently. I didn't pursue it. I chose to think of it as the universe doing what it occasionally does, providing a thread, leaving it to you to pull. I called Karen the night the ruling came through. She opened a bottle of her own wine, and we sat on the phone for an hour, and I told her everything that had happened, and she laughed in the specific, delighted way of someone who had been rooting for you from the beginning and is deeply satisfied to be right. "What are you going to do first?" she asked. I thought about it. "Sleep," I said, "and then figure out what I actually want." It was the first time in 8 months that question had felt like an adventure rather than a threat. The summer after the ruling was the best summer I could remember in years. And I don't mean that in an uncomplicated way. I mean it the way people mean it when they've been through something that cost them greatly and come out the other side knowing precisely what they value and why. I kept the beach house in Michigan. That had always been the part of the settlement I cared about most. Not financially, but in the way you care about a place where your children grew up. I spent 3 weeks there in July, the first real vacation I'd taken in over a year. Lily came for 2 of those weeks, between the end of her high school graduation celebrations and the beginning of her first summer job before college. Marcus came for a long weekend with his girlfriend. We grilled on the deck. We swam in the lake. We talked about things that had nothing to do with courts or attorneys or the past 8 months. On the last night of July, I sat on the dock after everyone had gone to bed and watched the lake do what it does at midnight, go completely still like a held breath. And I felt something I hadn't felt in a long time. Not happiness exactly, not yet. Something quieter. A recognition that I was still standing, that I had stood when it mattered, and that the ground under my feet was finally genuinely mine. Back in Chicago, my work had continued. The mixed-use development in Wicker Park finished on schedule. I took on 2 new projects, a residential restoration in Hyde Park and a commercial renovation in the West Loop. My firm offered me a senior partnership, which I had quietly been working toward for 4 years, and which the distraction of the divorce had almost cost me. I accepted. I sold the Wacker Drive property, as planned. The proceeds, together with my share of the investment portfolio and the Wilmette settlement, meant I was financially independent in a way I hadn't been since the early years of my marriage, when I'd been building my career alongside someone I trusted to build his honestly. The difference now was that I trusted myself. I ran 3 mornings a week along the lakefront. I had dinner with Deborah Mensa twice, and we developed something that felt like the beginning of a real friendship, the kind built on mutual recognition rather than circumstance. I went to Karen's birthday party in September and danced badly and laughed genuinely and drove home feeling lighter than I had expected. I started dating again the following spring, carefully, at my own pace, on my own terms. I am not going to tell you about that in detail because it is mine, and some things are allowed to stay that way. What I will tell you is that I was happy, not in spite of what had happened, but with a directness that came from having gone through it. And then there was Daniel. I didn't track his situation actively. That would have taken energy I preferred to spend elsewhere. But information reached me, as it always does, through the ordinary channels of a city where people know people. The perjury referral from Judge Gaines' ruling resulted in an investigation by the state's attorney's office. Daniel's second attorney managed to negotiate it down from criminal charges to a formal sanction. He avoided prosecution, but the public record of the financial concealment findings followed him. Commercial real estate is a relationship business. several of his long-term clients quietly moved their management contracts to other firms in the months after the ruling. His reputation, which had been built on the appearance of solid, trustworthy management, had a crack in it that didn't close. Kristen Walsh, whose LLC had been ordered dissolved and whose assets had been returned to the marital estate, found herself in a position I imagine was both complicated and instructive. The money she had expected to receive, Daniel's reallocated assets, the portfolio, the properties, was gone. What remained, as far as I could determine, was a relationship with a man whose finances were now substantially more modest, whose professional standing was diminished, and whose central defining strategy had failed publicly and completely in a courtroom. I heard through Karen that they were still together. I found I didn't care, one way or the other. What they had between them was their business. What had been mine, I had taken back. I thought sometimes about the anonymous text message. I never solved it definitively, but I made peace with not knowing. Some gifts don't come with return addresses. The beach house, the partnership, the friends, the lake at midnight. I had built a good life once. I had watched it be quietly dismantled, and then, because I had paid attention and acted deliberately and refused to mistake peace for surrender, I had built it again. Better this time. More mine. If this story taught me one thing, it's this. Signing your name is not the same as giving up. Sometimes the most powerful move is the one that looks, to everyone watching, like defeat. I lost nothing by waiting. I lost everything by almost not starting. Don't let anyone convince you that peace and surrender are the same word. If someone is quietly dismantling what you built, pay attention. Document. Find people who will tell you the truth. And then act. What would you have done in my place? Let me know in the comments. And if this story stayed with you, you know what to do. Thank you for listening.